The question for today is whether a US citizen can petition for an immigrant spouse if it's not their first marriage to an immigrant and they previously sponsored their ex-spouse. So let's say a US citizen marries an immigrant and they petition for that immigrant, and that immigrant becomes a permanent resident. And then they get divorced at some time thereafter. And then the US citizen in the future, whether it's 5, 10, or even just 1 year later, marries a new immigrant spouse and wants to petition for them. Can they do that, and what complications arise in those cases? So the short answer is yes, they can do that. And I have cases where the US citizen is on their third or fourth marriage, and one or more of their prior spouses were also immigrants who obtained an immigration benefit. The question for USCIS is twofold. First, does the US citizen petitioner, the US citizen spouse, meet the financial requirements for this new marriage's affidavit of support? So the first thing that they look at is, what is the US citizen's household size? And when we calculate household size, generally, we are looking at spouse, kids, any other dependents on the tax return, but also any prior immigrants who were sponsored by this US citizen who are still a permanent resident and who have not worked for more than 40 quarters. So basically, the question is whether the US citizen's prior affidavit of support obligations continue to exist. So if a US citizen sponsors someone to become a permanent resident, they are responsible under the affidavit of support for that immigrant who's now a permanent resident until one of two things happen. One, until that permanent resident, in this case ex-spouse, becomes a US citizen, or two, until that permanent resident has worked for 40 quarters, which if you work continuously would be 10 years of continuous employment. At that point, the affidavit of support obligations cease to exist. So if the US citizen petitioner in this case divorced his ex-immigrant spouse a couple years ago, and that ex-immigrant spouse hasn't worked for 40 quarters with their green card and is not a US citizen yet, then we need to add one person to the household size when we're calculating the affidavit of support requirements. The affidavit of support requirements, for people who don't know, are pretty low. Like, the income requirement for a household of 2 is just under 27,000 for most people. And you pretty much add like 6,000 to 7,000 to that base income for each other family member. If you want to see an actual chart that explains the income requirements, just go to Google and type I-864P, and it'll show the affidavit of support poverty guidelines chart that shows what your income needs to be based on your household size. The second question that the USCIS officer might be wondering is, this US citizen petitioned for an immigrant before, and that immigrant became a permanent resident. Is this marriage now real? Or is the US citizen involved in some sort of like scam or fraud scheme where they're just helping people become permanent residents through fake marriages? That question comes up a lot during consultations. People ask me if USCIS is going to think that the marriage is fake. And my answer is not if the marriage is real and you have evidence that the marriage is in good faith. So when the US citizen has married another immigrant before and that ex-spouse now is a permanent resident, it's important to beef up the evidence that we submit with this new application. We want to really show that you guys are living together, sharing your lives together, and if possible, we also want to show some financial commingling, mixing of your finances. And great evidence that really sets cases apart is evidence of travel. I really like to focus on evidence of travel because I think that immigration officers kind of back off when they see that you guys have actually been on vacations together. It's hard to fake stuff like that, like flight confirmations, hotel confirmations, photographs in a lot of different settings, ideally over the course of several years. Like, these are the types of evidence that I really like to focus on when this is not the first marriage to an immigrant spouse and we need to prepare for the interview. Just to summarize, the answer is yes. A US citizen can petition for more than one immigrant spouse over the course of their lifetime. And yes, these cases regularly get approved, but you need to really focus on evidence and make sure your evidence is strong first when you submit the application, and it needs to be even stronger by the time you attend the green card interview. If you are interested in applying for adjustment of status, or you need any advice or guidance in your immigration process, please schedule a consultation directly with me. You can find my information in the video description below. If you're new to my channel, I like to put out informational videos on the family-based immigration process, naturalization, deportation defense, and changes to the Trump administration's immigration policies. If you want to learn more about these things, be sure to subscribe, and I'll see you guys next time for another video.